so delighted to return to you with a new series of talks. My name is Jenny Wild. I'm a director and solicitor at Ridouts, and I welcome you to our session today, which will be covering legal issues arising out of lockdown number 3 and an essential look at where we're at with COVID-19 within the health and social care sector. It's been almost a full year since lockdown started, and as a sector, we've changed forever. Things are unlikely to ever be the same again, but what we'll be looking at today are the legacy issues. What has changed now, what's likely to change in the future, and what you can expect as providers going forward. I'm lucky enough to be joined this morning by 3 of my colleagues from Ridouts. Starting us off today will be Senior Associate Solicitor Laura Payton, who's going to be looking at the CQC perspective of lockdown number 3. The presentation will look at CQC's most recent approach to inspections and their proposals for the future of inspections, so you as providers know what to expect from the regulator. Then we'll be moving on to my colleague, Solicitor Gemma Nicholas. Gemma's got a very hot topic that we see a lot of questions popping in from clients about, and she will be covering the issue of mandatory COVID-19 vaccinations for for healthcare workers rather, and visitation within care settings. So again, very pertinent and something that's changing almost every day. And finally, to round things off, we have Paul Ridout, our Managing Director and Solicitor. And Paul is going to be going beyond COVID and looking at commercial relationships beyond the pandemic, looking at insurance issues arising out of what's happened over the last year and things from more commercial perspectives that might be affecting providers. Now, if you have any questions throughout the presentations, please save them towards the end, or you can add them into our Q&A box that you should see at the top of your screen, and I will aim them at presenters towards the end of the talks. If you've got anything that we don't address, we will be making a list of all the questions shared and trying our best to answer those after the webinar. So hopefully everybody's questions do get answered. So, as I said, this is the first in our series of spring webinars, and we're happy to kick things off with Laura Payton.
Thanks, Jenny. Hopefully everyone can hear me okay. I would say nice to see you all this morning, but I actually can't see anybody, and I can't wait for the return of live events so that I can see the whites of people's eyes at these talks and see whether what I'm saying is actually of any interest or whether I'm boring you to death. But hopefully you're still riding on the back of your morning coffee and ready to go this morning. So as Jenny said, I'm going to look at CQC inspections during this 3rd lockdown and beyond. And can I get the next slide, please, Jenny? Just a little whiz through what I'm going to cover in my talk. So I'm going to look at where we're at just now with CQC inspections and go through what got us here from lockdown 1. I'm going to give you a little bit of insight into what we've seen with clients as sort of hot topics arising out of inspections and issues and how to address them. And then we're going to look at moving forward from lockdown, moving forward in CQC's future plans and some of their quite bold plans around inspections, ratings and consultation. Next slide, please. So CQC's changing role, and this is really through the COVID pandemic really. So it was probably around about this time last year that it all started. At the beginning of the pandemic and the first lockdown, you'll remember that CQC took quite a hands-off approach. They suspended inspections and they had what many providers saw as a much more supportive role. And that's certainly actually something that we witnessed at Ridouts as well. And I think some providers found that quite a new approach from CQC and quite refreshing. They worked towards what they were going to do to regulate during the pandemic, and in May 2020 they introduced the Emergency Support Framework, which I'm sure you will all recall, where you had calls with inspectors rather than site visits. In August they introduced the Infection Prevention and Control inspections, which are still ongoing. Can I have the next slide, please? And then in October 2020, the Emergency Support Framework was replaced with the Transitional Regulatory Approach, And the work under that is called transitional monitoring activity. So many acronyms, TRA, TMA, I keep getting myself confused with them. Around about that time in October 2020, we saw CQC making a commitment to the return to on-site inspections and crossing the threshold, as they said. So that was sort of lockdown 2, October, November time. Can I have the next slide, please? And then moving into lockdown 3 and what we're going to look at today, CQC are still crossing the threshold. Now, what I'll say is, I'll caveat this talk, I'm going to give you some insights into what providers have faced, but at Ridouts, and well, for me certainly, nobody ever phones me up to tell me they've had a good inspection report with CQC, or they've had a good outcome. All of this is based on CQC sort of concerns that providers have had. But what we have seen, certainly during this lockdown, is that CQC are continuing to cross the threshold of services. They say they're doing this on a risk basis mainly, so that's where they see risks to service users. Perhaps it's in response to immediate concerns such as whistleblowing, and we've seen a lot of inspections arising out of whistleblowing concerns. What we've seen, and I've seen, I can think of at least 6 or maybe 7, perhaps more inspections where CQC have come out to a provider to do what's called a targeted inspection, which you'll know under their provider handbook is in response to a specific issue. They don't change ratings, but what CQC have done is, having crossed the threshold and looked at other issues, they've expanded those inspections out to focused inspections. And of course they do change ratings for providers. And that has led us to get queries from providers who've got concerns or inspection reports that they're not happy with coming out of focused inspections. So things to think about in terms of the targeted inspections and focused inspections, and what we've seen is that CQC seem to be spending a lot less time on site. A lot of what they're doing is paperwork focused. I can certainly think of a handful of occasions where providers have said, CQC have not spent longer than 2 or 3 hours in the service. They've asked for a whole load of information either before or after, but they've gone away and looked at the ratings of usually safe and well led. Can I have the next slide, please? So that leads us on to the types of things that people have been in touch with me to challenge, and the importance of these. And what I would say, from the outset of the pandemic, there has been a huge increase in the number of alleged regulatory breaches being put in draft inspection reports. Now, they're obviously significant because, ultimately they're a precursor to enforcement action, but they are very important for providers to ensure that they are challenged if necessary because of the impact they have on ratings. It's always been the case that if you have a regulatory breach in any domain, then CQC can use its discretion to rate your overall rating for the service to requires improvement. Now, that's always been a rating limiter. Previously, it was sort of buried in the provider handbook, but in September 2020, CQC updated the provider handbook to make their position clearer about rating limiters, and you'll see if you look at that, it's quite clearly there. Now, what's the practical impact of that? Again, I can think of, and actually I think every factual accuracy, and there have been a lot that I've done over the last lockdown year, has had alleged regulatory breaches in it. When we've gone back through factual accuracy comments, we've had at least one of these breaches, if not 2, sometimes more, removed, and sometimes the ratings changed as a result. So that's a key trend and theme that we've seen. Another thing that we've seen a lot of is an increase in letters of intent. Now, these are a precursor to Section 31 actions. Section 31 is CQC's, or one of CQC's, urgent enforcement powers, where they can take a wide range of action. Generally, what we see is imposition of conditions, but depending on the way your registration is set up, it can ultimately lead to the cancellation of services. So they're very important. What are letters of intent if you've not experienced these before? A letter of intent is essentially, well, clues in the name, CQC writes to you to say that we intend to take urgent enforcement action. They tend to send these last thing in the day. They usually give you 24, perhaps 48 hours if you're lucky to respond, usually asking for an action plan to set out how you will address the issues that have arisen, and you have essentially 24 or 48 hours to persuade CQC that the action that they consider taking is not necessary. And we've seen a lot of that. Some of it has come out of crossing the threshold and CQC going into services. Some of it has arisen actually out of whistleblowing. I saw one recently, one that we were actually successful in managing to put a stop to, arose out of a whistleblowing complaint. And essentially, if CQC had made the necessary inquiries, which they could have done in a less draconian way, they would have been able to see that the enforcement action wasn't necessary. But anyway, it was resolved. But that's something to keep an eye on. CQC will usually remind you, because of the importance of it, you should consider taking legal action. And I think in those circumstances, I mean, you'll say I'll say this anyway because I'm a lawyer, but when enforcement action is threatened, it really is quite important. Another theme that we've seen, and this is an interesting one, is an increase in warning notices. I'm actually due to deliver some training internally on warning notices. And maybe about 6 weeks ago, I was chatting to a colleague and I said, oh, God, I don't know what I'm going to cover. I haven't seen a warning notice, probably for the length of the pandemic. Well, I shouldn't have said that. Since then, they've been coming in like buses at the service. Colleagues on this webinar today, I certainly as well have dealt with them. So we've certainly seen an increase in the very sort of recent times in warning notices. Warning notices are sometimes things that providers see as sort of low-level enforcement action. And they might think, well, I'm not going to respond to this, or I can't respond to it. First of all, you can respond to it. You get 10 working days, just like you do for factual accuracy comments. Why would you respond to it? Well, it links back to what I've said above about regulatory breaches, inspection reports, and rating limiters. If you don't respond to a warning notice, which is essentially a warning from CQC that they consider that you're in breach of the regulations, they could take that as your acceptance that you're in breach of the regulations. They will no doubt update your inspection report to reflect that. And as I've mentioned above, CQC has discretion to apply regulatory breaches as an overall rating limiter. I would say that is discretionary, and I'll come back to the reason why that's important just sort of in the next, I think it's in the next slide. The final thing, and I've touched on this already, and I think this is something we're going to see a lot more of, and a lot more of going forward under the new plans that CQC have, but it's the lack of detail and explanation regarding changes from targeted inspections to focused inspections. They're supposed to do it on the basis of risk, but quite a number of providers that I have dealt with who have experienced this are actually not clear why CQC have expanded that out. It's not been communicated properly. And then it's not clear whether CQC have actually followed their own correct inspection methodology for focused inspections when they have carried that out. So that's trends and themes. Can I have the next slide, please? So challenging reports and ratings. Anyone who has been on one of these webinars before, been to any Ridouts events, spoken to me, will know that I've done a lot of these talks, and I don't intend to repeat my usual talk on challenging reports and ratings, but I just have one slide on it. If you do want a bit more detail, I did address it in our webinar series last lockdown, and they're all on our website and on our YouTube channel. But what I would say is that as usual, factual accuracy comments are your most important opportunity to challenge inspections. Rating reviews are essentially not worth the paper they're written on. You can look at the stats on CQC's own website. They're very, very often not successful. And then after you've got to that stage, your only option is judicial review. The reasons why it's important, I've mentioned this already, regulatory breaches in any domain are rating limiters, although that's discretionary. Another one, if you have a persistent requires improvement rating and well led, CQC can then decide in your next inspection to apply a breach of regulation 17, which of course is a rating limiter, so it's all a bit circular. Really important to put your position on board, put your position out. Why is it important to talk about discretion? I'm not going to give you a public law lecture, but all of these limiters are discretionary. CQC is a public body. They have to play by public law rules, and broadly speaking that means they have to exercise their discretion in a way that's reasonable, rational and proportionate. And if they don't do that, then those decisions are capable of challenge, but that challenge is via judicial review, which can be can be tricky, it can be expensive, but it can work in the right case. We've had a number in the not too fairly recently, and colleagues on this webinar have been involved in some as well, where with the right case it can really it can really work. Sorry, I've just seen a question pop up, factual accuracy comments. Sorry, got too used to using acronyms that I assume everyone is used to. Yeah, your factual accuracy comments are the opportunity that you get 10 working days when you get your draft inspection report to respond to that report. So I think that takes us up to where we're at just now. If I could have the next slide, please. To look at CQC's future plans. Now, this is quite interesting, although quite lacking in detail. So I am slightly conscious of the time, but I'm also conscious that the consultations that have come out don't actually have that much detail for me to cover off. So I'll deal with the headlines. In January, CQC issued 2 consultation documents. The first one was on their strategy from 2021 and beyond, and that is the world of social care is changing and so are we. That closed on the 4th of March, so I don't propose to spend any time on that. We do hope to run a future webinar on the outcome of that, depending on when it's published. Can I have the next slide, Jenny? What I am more interested in talking about, and I've got a copy of it here, is CQC's future plans, and this consultation document, which you probably can't see actually, is on their website, is their consultation on changes for flexible regulation. And that contains CQC's proposals to be a more dynamic and proportionate and flexible regulator. Lots of words that we've heard a lot during the pandemic. And I do want to bring this to your attention today because it has some potentially significant changes to the way CQC are going to approach inspections and ratings. And it's open for responses until 5 o'clock on Tuesday, the 23rd of March. So you've got plenty of time to have your say. Can I have the next slide, please? Broadly speaking, it's in 2 parts, and it's got potentially significant changes. They're looking at moving away from a scheduled frequency of comprehensive inspections that change ratings. So that's at the moment, you know roughly when to expect CQC back out. For example, 12 months if it requires improvement, 18 to 24 months for good, and outstanding, 6 months for inadequate. It raises the possibility of changing ratings more frequently without site visits. And it also contains some changes regarding how CQC is going to consult with you in the future. Can I have the next slide, please? So it's in 2 parts. The first part of it deals with CQC's plans to assess quality and rate services using a wider range of regulatory approaches, not just on-site or comprehensive inspections. As I've mentioned, they want to switch from a fixed schedule for how often they assess and rate. They're also going to stop providing separate and distinct ratings for the 6 population groups when they're rating GP practices. And they're going to remove the aggregation for NHS trust level ratings and replace it with a single trust level rating. Now, those last 2 bullet points there is actually not a lot of detail in the consultation about that. I attended a CQC webinar on it as well to try and get a bit more information, but it wasn't really forthcoming. So we need to keep our eyes out for that. But just focusing on the first 2 bullet points, if I could have the next slide, Jenny. So they've said they want to shift away from current frequencies, but the consultation document, I've read it from top to bottom, there's actually no information about what the new frequencies might be or how they might assess that, how often they might come out, when you might expect it. They've said that site visits, so your typical inspection, is not the only way to assess quality and update ratings, and they intend to use wider sources of evidence, tools and techniques. But again, those are not defined. And they do say that they still propose to carry out on-site inspections where there's information about significant risks to people's safety and to ensure protection of the rights of vulnerable people. Next slide, please. Interestingly, they are going to move away from PIRs, or certainly that's the suggestion, and they want to make assessment activity more targeted and focused. Again, there's no detail exactly of what they'll ask providers to do, but they've said, and I quote, "If we need to ask health and care providers for information before an inspection, the request will be targeted and proportionate." Can I have the next slide, please? And that will be interesting to see how that plays out. In terms of ratings, they want to take a less rigid approach, and this is back to something that I think they used to be able to do, sort of desktop changes to ratings, so that they can review the ratings and quality in a service more often. What's interesting, I think, is that they're going to look more at people's feedback and experience of care. And they say they're going to use a combination of targeted inspections. So those are the ones that historically wouldn't have changed ratings, but that seems to have changed. They're going to look at national and local data and insight from other organisations, and also from relationships with providers themselves and their own self-assurance and accreditation. Can I have the next slide, please? So just reflecting on that before we talk about consultation, I think that's going to be really interesting for providers, and it could cut both ways, but I'll summarise that just after we've gone through their proposals for consultation. Now, I don't propose to go through this in much detail, and you may think it's not that interesting, but snuck into this consultation is CQC's proposals to change the way it engages and consults with stakeholders in the future. Now, what they've said is that they consider that its current approach goes beyond what they're required to do in terms of the Health and Social Care Act 2008, and that actually that limits the CQC's ability to be dynamic and responsive. And they're proposing a shift away from large-scale formal consultations to more targeted conversations, they've said. So, for example, through focus groups and the Citizen Lab platform, which some of you might be familiar with. Can I have the next slide, please? So in terms of the impact on providers, well, clearly everything I've read about this consultation talks about the lack of detail, and it is disappointing that it doesn't have more detail in it. We don't really know what the exact details of their plans are, and that needs to be fleshed out. There will be positives and negatives of the rating changes being able to be done more frequently. I know a number of providers who've been stuck with a requires improvement rating, perhaps unjustifiably, that have had to wait months and months to be re-inspected. And that's great, but when we talk about the other end of downgrading ratings, well, what information is CQC going to look at? What are these additional sources of data? Is it going to be triangulated? Interesting as well is the focus on feedback and service user and relative and resident and no doubt staff experience. That's another one to watch, and perhaps providers on this webinar have experienced it. Certainly we have on behalf of clients. How often do you see CQC latch on to one comment from one service user or one member of staff, quite often around staffing, and then that translates itself into a conclusion in the report that you don't have enough staff, and that's based purely on opinion evidence which hasn't been checked. So we need to be careful that reports don't turn into essentially TripAdvisor reviews of services. You know, there has to be real triangulation of evidence and looking at documents properly. And the other thing, which is of interest to me, but should be of interest to you as well, is how will providers get the opportunity to challenge inaccurate reports and ratings under the new system? Will there still be factual accuracy comments? A couple of years ago, CQC mooted drastically cutting the time that providers had to respond to inspection reports, and I was at a sector conference where CQC were speaking and providers were quite rightly up in arms about that. 10 days is already quite a limited period if there's a lot to respond to, and we can only expect that if reports are going to be shorter, less detailed, less triangulated, then there may be more need for challenge. Can I have the next slide, please? So yeah, do have your say. That is the last slide. I was just going to quickly touch on the consultation point, and CQC want to change the way they consult in the future. The reason that that's significant is that CQC are actually required under the Health and Social Care Act to consult on the way that it assesses and regulates services, and they're supposed to put proper documents out in the public domain for providers to comment on. They have in the past got into hot water from not doing that. An example is they rushed out the first version of the Registering the Right Support document, which deals with registration of learning disability services, and that ultimately had to be withdrawn because it wasn't consulted on. I think it's very important that CQC don't try and derogate from their legal obligation to consult properly with providers, and sneaking through this sort of new formulation of consultation on Citizen Lab, I'm not sure will be the correct forum. But anyway, you all have the opportunity to have your say on that. The links to the consultation are here. I've also, for what it's worth, but it doesn't contain much more detail, I've also written an article about the most recent consultation, which will be coming out in the Ridouts report, which I think is due to come out at the end of this week. So if you are not already, then make sure you sign up to our report. And I'll leave you at that because I think, as usual, I've gone over my time. I can see everyone glaring at me. So thanks. I look forward to getting questions at the end of the webinar.
Thanks so much, Laura. Obviously, lots changing, and we encourage providers to get involved with consultations where they can in order to shape the future of the CQC's approach. So now we'll move on to our colleague Gemma Nicholas, who's going to look at how providers are facilitating visits under ever-changing guidance, and also the issue of mandatory vaccinations for social care staff. So Gemma, over to you.
Thanks a lot, Jenny, and good morning, everyone. So as Jenny said, I'm covering vaccinations and visiting. What I plan to do on the next slide, it shows what I'm going to cover, which is whizzing through the myth busting, so some myth busting on vaccinations, and then also considering vaccinating residents and also vaccinating staff. Then in relation to visits, I will cover how care homes can facilitate visits using the new guidance published last Thursday, and how safeguarding and human rights plays a part in visiting. Next slide, please, Jenny. So there is a lot of information floating around about the virus. For obvious reasons, it is important that people know the facts, as this will help people to make informed decisions about the vaccine. Briefly discussing the common misconceptions on the next slide. The first one is that one vaccine is better than the other. In the UK, 3 COVID-19 vaccines have been authorised by the MHRA, the Pfizer-BioNTech, the Oxford AstraZeneca and the Moderna, which may become available for use in the spring. It's hard to compare like for like. The main thing is they all work, otherwise they would not have been approved. Another misconception is that the vaccine gives you coronavirus. The vaccine cannot give coronavirus. They contain the genetic sequence found on the surface of the virus. And as there is no whole or live virus involved, the vaccine cannot cause disease. The genetic sequence naturally degrades after a few days. The misconception that there are bad side effects. There are 3 main types of adverse reaction following immunisation. Local reactions at the injection site, such as redness, swelling or pain. Systematic reactions, which are reactions affecting the whole body, such as tiredness, fever, headache or loss of appetite. And allergic reactions, such as anaphylaxis or severe systemic allergic reaction. A small number of people have experienced anaphylaxis when vaccinated with the Pfizer vaccine. On the 30th of December 2020, the MHRA issued revised guidance to say that anyone with a previous history of allergic reactions to the ingredients of the vaccine should not receive it. But those with any other allergy, such as a food allergy, can receive the vaccine. The vaccine is unsafe because it was developed too quickly. It's true that the COVID-19 vaccine was developed and tested more quickly than other vaccines, but that is because the circumstances called for speed. The vaccines that are authorised have been through 3 stages of clinical trials. The trial phases were organised to overlap, therefore speeding up the overall time of vaccine production. In addition, rather than waiting for the results of trials to manufacture a vaccine, the companies creating the vaccines produced them simultaneously so they'd be ready to deploy when the trials were completed. Regarding the vaccine having animal products, the MHRA has confirmed that the AstraZeneca and Pfizer vaccines do not contain any components of animal origin. The main ingredients include the genetic sequence, fatty lipids, which are a buttery substance which includes cholesterol, and salts and sugars. Also, I understand that many religious leaders, especially whose followers may be concerned about the presence of animal products, are involved in promoting the vaccine. And finally, the concern that the vaccine affects fertility and is unsafe if you are pregnant or breastfeeding. The latest advice from the JCVI is that the vaccine should be considered for pregnant women when the potential benefits outweigh the potential risks, or if the woman has underlying health conditions. It has been said that women who are breastfeeding can also be given the vaccine, and that the vaccine does not affect fertility. Essentially, children and pregnant women are not included in trials, but this guidance regarding pregnancy and fertility has come about because apparently some women in the trials fell pregnant and did not experience problems. So on the next slide, we consider the JCVI priority list. So as of yesterday, just under 22.5 million people had received the first dose of the vaccine, and just over 1 million have received the second dose. The vaccine has been rolled out in 2 phases based on the priority list. The first phase started in January and will end on the 15th of April and includes older care home residents, care home workers, health and social care workers, clinically extremely vulnerable people under 70, those aged 16 to 65 with underlying health conditions, unpaid carers for the elderly and disabled, and all those aged 50 and over. Phase 2 will be from mid-April to the end of July and will see those aged between 18 and 49 being offered the vaccine. It is now the case that those with Down syndrome and severe or profound learning disabilities in long-stay nursing and residential care rank high on the priority list and are set to receive the vaccine before the 15th of April. Those with Down syndrome are now in priority group 4, and those with severe or profound learning disabilities are in priority group 6. However, adults with less severe learning difficulties or learning disabilities are not currently prioritised. Furthermore, GP systems may not always capture the severity of someone's disability, meaning some people who are more severely affected by learning disabilities may not be invited for vaccination alongside people with other long-term health conditions. I'm going to briefly touch upon best interest decisions. However, firstly, if a person has capacity to decide for themselves on the vaccine, it is wise they read the letter and consent form from the government, which records their decision of consent or refusal. If a person lacks capacity to consent or refuse, providers need to do all they can to ensure that the resident understands the information about the jab. The person who lacks capacity should be involved in the decision-making process, if possible, particularly if their capacity fluctuates. If the person definitely lacks capacity to make the decision about the vaccine, it becomes a best interest decision. So moving on to the case of London Borough of Hammersmith and Fulham versus W. This is the first reported Court of Protection judgment on capacity and best interest in relation to the vaccine. The case involved Mrs. E, an 80-year-old care home resident with dementia and schizophrenia, whose adult son objected to her receiving the vaccine. The Court of Protection decided that despite her son's objections, it would be in her best interest to be vaccinated against COVID. Her son, who did not have power of attorney, objected the day before the scheduled vaccination. Mr. Justice Hayden decided that Mrs. E lacked capacity to decide whether she should have the vaccine on the grounds that she was unable to understand, weigh or retain information concerning the existence and risks of COVID-19 because of her dementia. In determining best interest, Mr. Justice Hayden considered Mrs. E's past and present wishes and feelings, the beliefs and values that would be likely to influence her decision if she had capacity, and any other factors she would be likely to take into account if she were able to do so. Mr. Justice Hayden had regard to the fact that when she had capacity, she had received the swine flu and the influenza vaccinations. She currently wanted, in her words, whatever is best for me, and she was at risk of death from coronavirus because she was in her 80s, suffered from diabetes, lived in a care home which recently had coronavirus, and found social distancing difficult to understand. He concluded the vaccination reduced the risk of death dramatically, and he had no hesitation in concluding that it was in her best interest to receive it. So moving on to vaccinating staff on the next slide. There will be care homes with staff who have not yet been vaccinated. Social care workers are being invited to book via the normal booking system, which can be accessed online or by calling 119. When attending the appointment, the health or care worker will need to take photo ID along with either their work name badge or a letter from their employer. Regarding NHS numbers, I understand that having your NHS number to hand will speed up administration at the vaccination appointment, but people who do not know their NHS number can still obtain a vaccination. Staff are likely to consider whether the vaccination will protect the residents they care for, and the answer to that is the vaccine does provide some degree of protection. It is not yet known if the vaccine will stop you from catching and passing on the virus, but it is highly likely that any infection in a vaccinated person will be less severe, and that viral shedding will be shortened. Therefore, it is expected that a vaccinated person will be less likely to pass on the infection rather. That being said, after the vaccine, one still needs to wash hands regularly, socially distance, and wear masks. Okay, so you have the facts about the virus, the vaccine, the practicalities of getting the vaccine, and the fact that it provides some degree of protection for residents. But what do you do when there are still staff that refuse or are hesitant in having the vaccine? It may be better to seek to persuade rather than compel staff to get a vaccine by appealing to their hearts and minds, seeking to understand why they are reluctant, what are their reservations, responding with empathy, but provide factual information, addressing the issue of fake news regarding the vaccine, and encouraging staff to make their own informed decisions about whether to be vaccinated or not. However, in the last few weeks, we have seen a number of well-known care home groups introducing new policies requiring vaccinations for staff. One is requiring it for new starters, and the other is expecting all staff to be vaccinated by a certain date. This issue is of great concern because care providers are trying to balance the rights of employees against the need to protect staff and service users. From an employee's perspective, mandatory vaccinations require changes to an employee's contract. A jab for job contract could violate the Public Health Control of Disease Act 1984, which stops individuals from being forced to undergo medical treatment, including vaccinations. Also, where care staff refuse to have the vaccine for no medical reason, purely out of choice, if such refusal leads to the staff member leaving, they may claim unfair dismissal, constructive dismissal, or discrimination. From the employer's perspective, to combat an unfair dismissal claim in relation to requiring employees to get vaccinated, the employer could rely on their duties to both employees and members of the public, in this case service users, under the Health and Safety at Work Act 1974, which requires businesses to ensure a safe workplace environment and to take reasonable steps to reduce workplace risks. The requirement to get vaccinated could be deemed a reasonable management instruction, refusal of which could amount to a fair reason for dismissal. Constructive dismissal could be claimed if employees feel pressurized or forced into having the vaccine, so employers need to think carefully about vaccination policies. It's best to avoid introducing blanket policies. In relation to discrimination claims, bearing in mind what we've just discussed in relation to myth busting, employers should be careful when staff cite reasons for not getting vaccinated, such as allergies, pregnancy, or religious beliefs. Depending on the nature of a staff member's objections, they may be protected under the Equality Act 2010. Therefore, it's important that care providers follow proper procedures in addressing the objections and considering practical steps to deal with them, including offering alternative work arrangements. However, in all of this, dismissal should be the last resort. And until this issue has gone before the courts or tribunals, no one can provide a firm answer on whether a discrimination or unfair dismissal claim could be successful in cases where there has been a refusal to have the vaccine. So moving on to the next slide to look at care home visits. The government guidance on visiting in care homes was revised last week Thursday. The main change to the guidance is that from yesterday, every resident is allowed one single named visitor who can make regular visits. As part of a single named visitor visit, hand-holding can take place, but use of gloves will likely be encouraged as physical contact is to be minimised. PPE must be worn. That includes masks, aprons, and if possible, visors. It is not necessary that the visitor or resident should have been vaccinated, but it is necessary that the visitor is tested. If a visitor tests positive, the visit cannot occur. The visitor will need to take a confirmatory PCR test and immediately self-isolate. Screen visits, which are another type of indoor visit, will be able to continue, as will outdoor, window and pod visits. However, the revised guidance has increased the number of visitors allowed for screen and outdoor visits to 2. How the visit is conducted is completely up to the care home. They are to decide the length and frequency of indoor visits, taking into consideration, amongst other things, the layout of the home. Also, note that the revised guidance has introduced the role of essential caregiver, someone who carries out caring tasks that cannot easily be provided by a member of staff. Based on the frequency of their visits, they will have access to the same PCR and lateral flow testing and PPE arrangements as a member of the care home staff. The next slide lists some things regarding facilitating visits. This revised guidance will mean that visiting policies will need updating. Also, providers will need to develop dynamic risk assessments which take into account the individual needs of service users and the physical features unique to the care home. If there is a COVID outbreak in the care home, visiting must stop. However, regardless of a COVID outbreak, end-of-life visits are allowed to continue. Providers should communicate with families and visitors, helping visitors to understand the risks surrounding visits. Next slide, please, Jenny. The CQC recently announced that where they receive information from the public or through whistleblowing that gives them concern or indicates a closed culture, they may undertake a risk-based inspection. Information related to visiting which could trigger a risk inspection include blanket visiting bans where there is no outbreak, people being discouraged from having regular calls with loved ones, people not being effectively supported to communicate with relatives and groups that represent them, and people not being allowed to see visiting professionals. The CQC has said it will take swift regulatory action where it has concerns. Essentially, the individual must be at the centre of the decision regarding visits. Person-centred care involves recognising that part of people's identity and well-being comes from their relationships. Lastly, looking at human rights and visiting on the next slide, the Joint Committee on Human Rights has also considered blanket bans on visiting and has stated that blanket visiting bans are contrary to the rights of both patients and their families under the European Convention on Human Rights, the Code of Practice for the Mental Health Act 1983 and NHS England guidance. There is a tension between protecting the right to life, Article 2, by protecting those living and working in care homes from COVID, and the right to family life, Article 8, by enabling service users to maintain relationships through visits. Such decisions can only be made on the basis of an individualised risk assessment. Such risk assessments must take into account the risk to the person's emotional well-being and mental health of not having visits. So on the next slide, in summary, where decisions are being made, whether that is for visiting, testing or vaccination, the focus must always be on the individual needs of the person. That's all from me. Thank you so much for listening.
Thanks so much, Gemma. That was really interesting and lots of considerations there for providers going forward. So we've looked at what's happening as a direct result of the pandemic. And now Paul's going to take us into more commercial considerations arising for providers that relate to contracts, insurance, and other issues. So over to you, Paul.
Thank you, Jenny. Good morning, everybody. Thank you for being on our webinar. Excellent stuff from Laura and Gemma on new and developing situations. I'm going to revert to some old themes, really, because with all that is going on, one needs to reflect on the standard operational requirements and those important things that affect care homes and their very survival. And at the very centre of that is the commercial contract which exists. All revenue flows into a care home are dependent upon forms of contract which are very, very important. And we've given webinars about this before, we've spoken about it before, but the excitement of COVID and the recent developments and the arrival of the vaccination should not take care home managers' views away from checking and managing their contract arrangements. Without an appropriate contract and without a contract that covers appropriate terms and changes and circumstances, then the care home may find it difficult to enforce payments. Public sector particularly is not obliged to pay unless there is an appropriate contract in place. So this is a sort of a catch up on where we were. And as we approach a time when people will be reviewing their contracts, when they will be reviewing their fees, and they will be increasing and changing fees, the process of change is very important. And managers must not lose sight of this in all the COVID-related different circumstances, particularly with CQC perhaps taking a slightly different approach. So if we could move on, please, Jenny. Next slide. Yeah. Has COVID made any changes? Fundamentally, no. The principles and processes are the same, but the COVID climate may have shifted the focus on these important considerations. COVID inspections, enforcement, IPC inspections and outcomes, and the willingness to commission. What we're seeing is that, particularly in lockdown 3, CQC has been hugely focused on the infection control arrangements. And we are seeing time after time in the casework that we're doing is CQC is rushing in as a super COVID regulator. Now, what does this have to do with contracts? Well, contracting with the NHS and with local authorities is often governed to a large extent by the attitude of the regulator and the circumstances that affect the contract. So if regulators downgrade ratings to requires improvement or inadequate, it may well be that contracting parties, commissioners, feel unable to continue to commission or to even in some cases take action to cancel contracts or remove. So it's very, very important that the link to the commercial impact on the contract of CQC's snapshot inspections and instantaneous judgments, which may have a dramatic effect and may underline the contract. So it's important that those situations are dealt with very carefully and very thoroughly. And where there are disagreements, I mean, CQC, we've had come in and say, we're going to downgrade you to requires improvement because one of your staff was seen not wearing a mask in the garden. Completely unnecessary and completely unjustified, but let it go and requires improvement become your rating on the site. And you may find commissioners and their staff saying, well, we're not going to commission with you anymore. So think about that, think about how that works, and think very closely about how you protect yourself from that. That's all part of the modern approach to contracting. We've got a comment here about designated settings. Designated settings for COVID-infected patients was promoted as a way forward to release hospital discharges, but it requires very careful consideration of all those matters that Gemma and Laura have been talking about, and also the contractual arrangements. There are contractual arrangements to provide proper and safe care for residents. There are contractual arrangements and legal obligations towards staff. Actually having an arrangement where people who are at risk, people who are infected or likely to be infected are designated into particular areas requires consideration very carefully of how you manage the manage the setting, the safety provisions, and the contractual implications and the regulatory implications of taking on a much more dangerous environment. It's not just as simple as saying we're getting a bit more money. Now, we're running out of time, so I'm now going to run through some of the standard thoughts about contracts. Contracts are simple, but they're made complicated by a lot of these extraneous factors. Please, next slide, please, Jenny. Contracts are made between two or more people, making promises to one or more other people, and when they are a contract, the simple conclusion is that they're binding. Gentlemen's agreements are not kept. No contract, no obligation. So it's very important that you establish when there is a contract. Nothing special like any contract in health and social care. Health and social care are simple service contracts with service provisions, but they are different in that they have medium to long-term effects, particularly if made with local authority commissioners, but even with long-term residents. what is in the contract may seem partially irrelevant now, but it may have an effect a long way down the line, particularly as dependencies and needs and even financial resources of residents change. So if circumstances change, how can your agreement flex? The circumstances that change as a result of the COVID pandemic, how does that affect matters? How does that change the way in which you perhaps ought to think about interpreting, applying, and construing the contract? Next slide, please. Health and social contracts are simple contracts for the supply of goods, services, and accommodation. And that's the way to look at them. Before we move on to the next slide, can we just go back to that, Jenny, thinking? Yeah, in dealing with services, it's very important in the individual contracts, which may be in a schedule to a public authority contract or an NHS contract, or maybe in individual service user contracts where there are private arrangements, that the original condition and the original care needs and the services to be supplied are very carefully set out. That's just common sense to be saying what you can be expected to do and deliver in return for the fees that you're going to get. But it's also very important, and in COVID times with people undergoing rapid changes in dependency, it may well be that the change in dependency signals a need for a change in care services, increased staffing, different types of treatment, and different types of individual care. In order to be able to properly flex, those changes ought to lead to a consideration of what is the cash cost of that and whether fees should be adjustable. Now, you need to look to the contract. Does the contract allow for flexing of fees in relation to increased dependency? A large number of contracts don't. And as we shall see in a little bit of time, implied terms are very difficult to apply. Next slide, please, Jenny. These are the types of contracts that you may see. A framework agreement is one which sets the relationship between the care home and a local authority usually. Spot contracts or individual placement contracts, either local authority or private. Block contracts are contracts where a local authority agrees to undertake to guarantee to take a certain number of places. And contracts may be exclusive to particular people, or they may be a sole individual contract. Next slide, please, Jenny. Ideally, there's a carefully negotiated and drafted and signed agreement, but it may be that that is not the case. Often people are rushed into care homes. The CMA have suggested to us that great care and consideration is given to choosing and selecting a care home. That's not our experience. Often the care home has to react to a need, either an emergency from a local authority or the NHS, or even from families who are desperate to place. Where is the contract? Where are we going to find? What does it mean? Look at the correspondence, look at emails, look at text, look at phone notes. It may be very important to see, clearly there is a contract, but what are the contract terms? And how can those terms, if necessary, be changed? Next slide, please, Jenny. Yeah, the ingredients of a contract are an offer followed by an acceptance, but there must be value. Equivalence is not relevant, and there must be an intent to create a legal relationship. Next slide, please. Next slide, please. I'm going to skip over that one. Right. When you're looking for evidence of a contract, look at conduct, look at the course of dealing. And if you're wanting to avoid a contract situation has arisen, either expressly deny that there is a contract. Lawyers express negotiating times by the expression subject to contract. The expression without prejudice is a way of negotiating a dispute, and it does not prevent a contract becoming binding. If you offer something without prejudice and it's accepted, it's still a contract. Read, check, understand, question, and take time both to formulate the contract and to understand what the contract is. Next slide, please. Changing a contract, this is the last point, really. Once you have a contract, you're bound. You cannot change it unless it's agreed by all parties, no matter how unfair or harsh the result. So we see contracts particularly with local authorities, where there are no provisions for price increases. That's very harsh over what may be a 5 or a 10-year contract. The fact that it's harsh or unfair doesn't mean that it's not binding. And with long-term and medium-term contracts in the care sector, this is particularly important. Change is ever so important. So can we move on, please? It's not the detail of the change, but the process. The law interprets what the contract is, and it tries to interpret that by looking at the plain and ordinary meaning. The law does not make contracts. Next slide, please. Contracts should be clear and precise. They should not be ambiguous. The services are simple, and the contract terms should be simple. Next slide, please. If something is missing from the agreement but needed, can we imply into the contract a term? This happens much more often than is necessary. And the simple answer is that this is very, very difficult. The law will allow terms to be implied into the contract, but only if it is absolutely necessary to make commercial sense of the contract. Don't think that you can rely on saying that must have been agreed, that is always the way, that is necessary is the answer. It must be necessary to make the agreement make business sense, not necessary to make business sense for one party, but necessary to give an effect of mutuality to the arrangement. Next slide, please. Yes, we'll move straight on from that. Contract disputes. You have to look to the contract, and then you have to look carefully to the breach. Particularly in the COVID times, we have seen a number of contracts with local authorities, where the local authorities are extremely lazy. When they come to allege a breach for their own purposes, whatever it may be, to try and suspend contracts, placements, terminate placements, they like to make wide-ranging and open allegations of breach, which entitles them to take whichever course of action it is that they want to take. But one should hold them to account to identify precisely exactly what it is that you've done wrong that entitles them to take the particular remedy, and maybe even think about preventing action which is going to be hugely damaging to you. If the local authority start to cease to make placements, to remove placements, to impose conditions which make it impossible for you to run your business properly, then you need to look to the contract. The local authority are not necessarily right. They are often wrong. And with private customers as well, it's the contract that matters. As you negotiate with them, as you have discussions with them, look at that contract. Next slide, please. We won't talk about compensation as time is getting beyond us, so let's move on to the next one. And the next one. If you want to terminate the contract, or if someone is suggesting that they want to terminate the contract with you, the first step is to read that contract, check the terms. There's no such thing as a perpetual contract. At common law, reasonable notice can always be given. Either the contract provides for notice, or if there is no provision for notice, what is a reasonable period of time? And the way that has been interpreted by the courts over the years is what is a reasonable time for the parties to make adjustments so as to carry on after the termination of the contract. Next slide, please. I think I just wanted to touch on insurance issues because they do arise out of contract as well as out of pure insurance. There will be more and more difficulties securing an insurance cover, particularly for employee and public liability. That may relate to high premiums. It may relate to refusals to insure. If that is the case, then it may be considerably damaging to your business. And if you're not able to insure, you may not be able to meet your contractual obligations. So it's very important that you look to that. Insurers are not obliged to insure, and they are not obliged to maintain increases in premium down to reasonable levels. just touching finally on the Department of Health and Social Care has indicated a targeted time-limited state indemnity for care homes where insurance is not available. Be very, very careful about this, because the situation will arise when there is a difficulty, when there is a claim against you. Will that indemnity protect you? Will it not protect you? Will it actually give comfort to your staff and to your customers? Will it particularly give comfort to local authorities and the NHS? It's only a temporary solution. It's said to run out at the end of this month. We here would not encourage you to think that that is a fail-safe protection. Thank you very much. Thank you, everybody.
Thanks, Paul. Thank you, Laura, Gemma and Paul, for those insightful talks. We are just running into past 11 o'clock, but we do have a couple of quick questions. I'm going to pick one, and as I said at the beginning of the presentations, we will address these outside the webinar on our website, but this is just a quick one for Laura. And I'm picking this question just because I think it will affect a lot of providers on the call, and it relates to the kind of new way that CQC are inspecting. This is a question from a provider who's overdue a visit for a good rated service and then not deemed to be at risk. And this is a thing that we've kind of found with a lot of our clients, people that provide good services that think that they could be outstanding or that there requires improvement but think that they could be good, are really waiting for an inspection, and they're kind of being frustrated by this new system. What would you say to those providers? Is there anything they can do to compel an inspection? What's the likelihood of them being inspected, and what's their position really?
Yeah, it's interesting, and it's something that comes up quite a lot. So it's a good question. In terms of, I certainly wouldn't wait for any new framework to come out under the consultation, because anything with CQC on that scale sort of takes time, and it is at the early stages of consultation. So you need to go by what the current position is, which is, of course, now if you're a good service, I think off the top of my head, it's 12 to 18 months. If you've not been inspected in that time, unfortunately, you cannot compel CQC to come out. However, certainly they're old strategy documents, not those that are under consultation at the moment, but they set out that CQC will inspect based on risk and improvement. Now, in the new consultation, they seem to have dropped the improvement and focus on risk. But I think you could legitimately, and we have advised clients to do this, to contact CQC and say, look, things have improved since the last time. We believe that we're due an inspection under the methodology. I mean, all of the methodology is guidance, but they do have statutory obligations to inspect and report. But it is quite a difficult situation, and I hope we will get a bit more clarity on what will happen once we have CQC's response to the consultation, which hopefully will be out in the springtime, and we can maybe do another presentation on that. But in the meantime, I would say, gather all your best evidence. It's kind of the way you would do for a PIR. If you have evidence of improvement, then put that to CQC. It's all good for inspection preparation anyway, so that when they do come out, you can put your best foot forward.
Thanks, Laura. That's helpful. Okay, thank you so much, everyone, for joining us. Apologies for the slight run over, but as I'm sure you can understand, there's so much to cover, so much has changed, and we hope that you found the information useful. If there are any questions that you didn't quite get answered today, please do get in touch. You can tweet us, you can contact us on LinkedIn, or email us at info@ridout-law.com. This presentation will be up on our website if you want to share it. That should be in the next day or so. And our events team are actually planning our next webinar in May, in a couple of months' time, and we're opening it up to providers again to suggest topics that they want to explore a little bit further, or have our legal team look into. So if you have any suggestions for that topic, please go to our website, which is just there on the final slide. In the meantime, if you want to keep up to date with our articles, what we're talking about, what our clients are finding, please follow us on LinkedIn and Twitter. And our website has a treasure trove of articles on all types of issues that hopefully you find useful. Thank you again for joining us, and thank you to our panel, and take care. See you soon.